Yeah, please, Lord. Praying for listing of a DA, my lord. As one connected matter is fixed tomorrow, my lord. Whereas all four, my lord. Rising out of same FIR, my lord.
It was fixed by this court.
Yes, my lord. Before this honor.
Pleasure losses, my lord, I beg to mention item 25, my lord. Case fixed for case diary, but I have heard from opposite side that case diary is not available. Interim may be continued.
CD not.
Interim shall be continued, my lord. I'm on bail. Item 25. Full? Obliging.
Hey, please, Lordship, I beg to. My lord, respondent number 2 service is not completed, my lord. Proxy is there, my lord.
Try for a report, my lord.
Hmm?
Try for a report, my lord. The CD is received, my lord. Can be taken up on, my lord, 9th, my lord.
First
Matter again.
please, your lordship.
Mention item number 39, your lordship.
Lordship, like English out of station, lordship.
I am appearing for the appellant, my lord. Immediately after view vacation, my lord, any date, my lord.
Oblige.
I beg to mention item number 40, my lord.
Same.
Item number 40, my lord. Kindly matter taken after view vacation, my lord.
Item number 29, we have made a mistake, my lord. 9 and 10 declared April 9th, my lord. Election.
May I please,
8, my lord.
lordship?
8.
May I please, the lordship? I beg to mention item number 43 of today's list. On behalf of my senior, PM Chaudhary, with the consent of opposite party.
I'm appearing.
I think counsel for the petitioner and the.
Lordship may kindly matter may be taken up after view vacation.
I'd like to pick for item number 34. My brother was engaged in this matter, but he got posted as a public prosecutor in Amingao. The DRI revenue has not engaged any other counsel yet into this matter. Kindly grant us some time.
Here. CBI.
DRI.
TRI. Joined as public prosecutor. New counsel.
Please, your lordship. I am praying on behalf of SM Abdullah, lordship, item number 46.
My lord. CD received, my lord. Needs to be approved.
46 CD received, but not in updated form. The matter again on.
Lordship, interim may continue. Interim order.
CD is to.
Much obliged, sir. Much obliged. Please, your lordship. I beg to mention for item number 22, my lord. Case diary along with the health status report was called for, but I have inquired, my lord. I think case diary is not available, my lord.
22. Cannot.
Obliged lords. 22.
But please, Your Lordship, I beg to mention item number 33, Your Lordship. I am for the respondent, Your Lordship, with the consent of other side. I have to submit reply, Your Lordship. My prayer for they may kindly be allowed, Your Lordship. Please.
None appears for the petition. Yes, withdrawn.
May I please, Your Lordship? Lordship, this is a 483 application. Lordship, petitioner was arrested on 30/11/2025. Lordship, this is a charge-sheeted matter. Lordship, under kindly issue the notice and call for that issue. Lordship.
Learned counsel for the petitioner and learned. Scan copy of the TR along with seat. Respondent number 2. Post to it edit.
Same matter. Lordship. Same affair. Same.
May I please, Lordship? Stated case, Lordship, and Lordship, the accused person was arrested on dated Lordship 5/7/2025, Lordship. And now the stage of this case is evidence stage, Lordship. And out of the total prosecution witnesses there and 2 seizure witnesses, out of 8 witnesses, Lordship, 4 main witnesses have been examined, Lordship. And Lordship, the 4 witnesses are the complainant, victim, the father of the victim, and the uncle of the victim, Lordship. From the statement, Lordship, of the victim, Lordship, it is clear that there is love affairs from the 2-3 years, Lordship, between the accused person and the victim, Lordship. The victim was 17 years 5 months on that day. And he stated, Lordship, in his cross-examination that he willingly went to the house of the accused person, Lordship. And Lordship, his statement, Lordship, is hostile in the cross-examination, Lordship. As per the statement 164, it was different, and the cross-examination, it was very different, Lordship. And in a judgment, Lordship, it is clearly said that if the statement is hostile, Lordship, then bail may be granted. And if it's a POCSO matter, Lordship, under section 4, Lordship. In the Supreme Court, there is that judgment also in POCSO case, Lordship, that is Maheshwar Tiga versus State of Jharkhand, Lordship. Lordship, citation may be written, Lordship, 4535, Lordship, AIR, Lordship, 2020, SC 743, Lordship. Para number, Lordship, 13, 14, 15, 16 is very relevant, Lordship. Lordship, the age of the accused person was only 18 years, Lordship. Lordship, the four witnesses have been examined and they have submitted your NOC, Lordship, in form of affidavit, that they have no any objection if the honorable court may grant bail to the accused person, Lordship. And the medical report which has been examined, Lordship, in the medical report, it is, it denies their physical relationship, Lordship. Medical report is in page number 23, Lordship.
It is from the husband of this petitioner, lordship. Now the summon was issued, but this section is exclusively traveled by the session lordship, special judge lordship. Then lordship, on appearance lordship, she may be detained in jail lordship until unless lordship committed the case.
Are you going to let us know about the fact?
Yes, lordship. Only lordship thinks is I am ready to appear lordship. Some protection lordship, I'll cooperate with the trial lordship. Otherwise, nothing has been recovered from this petition lordship. It's on page 14 lordship, is specific lordship. It's recovered from the 3% lordship.
Yes. Has been issued. Someone.
Yes, lordship.
It shall be released. Security of like and
Highly obliged. Wait, please, your lordship. Lordship, this is a FIR lordship, my PRS bail application FIR on page 11, lordship. Both the lordship, victim and the accused lordship in drunken condition lordship started quarreling with, in connection with the electric bill lordship. Then the accused lordship stepped this petitioner lordship, victim lordship. Now lordship, the informant lordship file an affidavit lordship. They have said, she said lordship, they have amicably settled the matter. Although lordship, the case was registered under lordship 103 lordship.
CD. Sorry, direct allegation against the accused.
Others are involved lordship.
Direct. Primary accused.
Date
On statement.
is from Nogao. So it will be too long lordship because on run
20.
lordship.
20 April.
Highly obliged.
It's a pre-arrest bail. The relationship between informant and the prisoner. After a broken relationship, she filed the affair out of revenge. There is in the page number 23. In the affair matter. Anpurvak Binito Nivedon is a শিৱ মন্দিৰ পদ প্ৰতিষ্ঠিত লাভ কৰোঁ আজিৰ পৰা ছমাহ ধৰি মোৰ লগত শ্ৰী চিন্ময় নাথে পালনাথ থাং আজাৰা তাঁতিপাৰা থানা কৰাম বুলি প্ৰতিশ্ৰুতি দি মোৰ পৰা প্ৰায় 3,30,000 টকা ব্যৱসায় কৰা উদ্দেশ্যৰে টকা লয় প্ৰায় 4 মাহ ধৰি মোৰ লগত সকলো ধৰণৰ কথা বতৰা আৰু একেলগে ফুৰা কৰিছিলোঁ এই দুজনৰ ভালপোৱা সম্পৰ্ক চিন্ময় নাথৰ মাক দেউতাকে জানিছিলে তেওঁলোকে ঠিকেই আছিলে তেওঁ মোৰ লগত শাৰীৰিক সম্পৰ্ক গঢ়ি উঠিছিল এতিয়া তেওঁ মোক বিয়া নকৰাই বুলি কয় আৰু তেওঁ বিভিন্ন অজুহাত দেখুৱাই মোৰ পৰা আঁতৰি আহে মই জানিব পাৰিছো যে তেওঁ বেলেগ ছোৱালীৰ লগত সম্পৰ্ক ৰাখিছে ইয়াৰ উপৰিও তেওঁ বহুত ছোৱালীক নিচা প্ৰলোভন দি জীৱন নষ্ট কৰি আছে মই এতিয়া মানসিকভাৱে ভাগি পৰিছো গতিকে মহোদয় চিন্ময় নাথৰ বিৰুদ্ধে বিহিত ব্যৱস্থা কৰে যেন This was the affair. A consensual relationship. The broken relationship, she filed the affair. Sir, my lord. PP.
Interim bail of rupees. Provided that the petitioner shall
Maybe first week of May, my lord. Yeah, plus.
Please, your lordship. 482 application, my lordship. The FIR is at page 14. Comment states that with due respect, I beg to state that Srimati Bimla Biswas, aged about wife of so and so, is my mother. She has been suffering from mental instability for a long time. Because of her mental condition, she could from her residence at Sriram comes to my residence. People in the locality often refer her to as a mentally disturbed. 2026 at about 8 a.m., my mother left her residence at Srirampur without informing anyone, and I came across a video circulating on Facebook where I saw that my mother was beaten and brutally assaulted by some person at Sapkata locality, who were accusing her of being a hopadhora, child lifter. The FIR is not against me. Particular person has been named in. 5 persons have already been arrested in. In the hue and cry, my lords, we went to the place of occurrence, were there, but we did not take part in the incident.
forwarding report. AB, my lord.
We are not arrested, my lord.
Some have been arrested.
5 other persons have been arrested.
Apprehension, my lord.
The apprehension, my lord.
What is the apprehension? Because
Because the
in
police
the
is
FIR,
not,
my lord, nobody named.
Yes,
may have been there in the Facebook.
I'm there, my lord. I'm there. I was there in the place of occurrence. I didn't take part in the incident, my lord. After hearing and hue and cry, I went to that place, my lord.
It's a serious case. Well, it's a lady. He will reveal.
In the interview, my lord,
No.
if I may.
Lordship, kind pass over the matter for the engaged counsel PK. Mother has gone to the hospital as her leg is fractured. He's on his way, your lordship.
This case, my lord, may be taken on the Monday, my lord.
Next.
His lordship. Lordship, we are filing the objection today. Lordship.
You are filing?
Objection. Here they filed, but it was filed in an appeal. It was for our prayer for return of seized articles and defreezing account was rejected. Lordship.
The prayer of how much time do you need? Time do you need to file the affidavit? Don't know.
I think 10 days.
Hmm?
10 days. কপি আজই দিয়ে আছে না? 8 টা পেপার। Obliged করছে, 8 টা পেপার।
It is lost. But the earlier my lord, bail was rejected, my lord. My lord, the new ground, my lord, if your lordship kindly turns to my lord, page 28 for a once, my lord. Page 28, my lord. Lordship, there are 4 accused, my lord. My lord, the petitioner before your lordship is, my lord, the serial number 4, my lord, Muhammad Habibur Rahman, my lord. All other petitioners were granted bail, my lord. Number 1, my lord, Shahid Alam was granted bail, my lord, that your lordship will find at page 71. And 2 and 3, my lord, they were granted by the apex court, my lord. Yeah, okay. March, my lord, the apex court has granted bail to the 2 persons, my lord, on the ground of, my lord, long incarceration. Prolonged incarceration.
Of the apex court.
Well, I have just now. Second page, my lord, paragraph 6, my lord. In regard to the submission made before us without expressing any opinion on the merit of the case, as also taking into account that the appellants have suffered incarceration since 17/10/23, we are of the view that appellants are entitled to be released on bail, madam. But I have given a copy to my learned friend also. Out of 12 witnesses, only 1 have been examined till date, madam.
Only one.
One, madam. Apex court order is of, my lord, this month, my lord, 16th of March, madam. Hmm?
Yes. They were arrested on the same date, I think.
What is the progress in the trial court? I mean, what is the grounds in the? Yeah.
I have not taken that ground. Parity does not disappear.
মই লিখিছিলো লিখিছিলো I have written, my lord, somewhere, my lord, it is there, my lord. My lord, page 13, my lord, paragraph 18, my lord. Is it? That the accused petitioner begs to submit that one of the co-accused in the instant case has already been granted bail by this honorable court, dated so and so. Therefore, he may be also allowed to go on bail considering the ground of parity in the instant case.
Shall representing. Yeah, right.
Yes, NCB.
In right. Bail. Long incarceration. Depends on the same having been be disposed of. Trial.
I'm obliged, my lord.
May it please, Lord. No, it's a regular bail application, my lord, and an interim bail, my lord, passed by your lordship on 4/12/2025, my lord. Was there, my lord, but there was no acknowledgement, anybody, my lord, that it was on that count, my lord, document 4/12/2025.
Yes.
My lord, that actually all right, my lord. And my lord, report from my lord, the transport officer. My lord, that like this, the vehicle could not put tested due to impact of the accident. Bound down the vehicle. Out from that vehicle, my lord. Are there any technical one died on the at the spot, my lord, another died
girl's injured.
Was
And
returning
and
from,
he is the driver, the petitioner is the.
yes,
the
sir.
pay.
Was returning from the attend postdoc, my lord. Is that 14 notice were received by somebody or not, ma'am?
Exact word may be quoted.
Exact word is what?
Due to of fury. Report from the hospital.
Down. Text.
Chairman.
Yes.
Initially, my lord, that was. I'm sorry, my lord. 11, 22/11 till my lord 4/12. 14 days, man.
10 days.
Was pleased to grant interim, my lord. He was arrested on 22/11, my lord. And 4/12 bail was granted at that line.
Dated 4/12/2025. Much obliged, man. Regular bail, my lord. Regular bail, my obliged. Man.
Please, Lord. I actually, yesterday evening, I filed Wakalatnama on behalf of respondent number 2 to 6, private respondents. I desire to file affidavit in opposition for the cancellation of bail prayer is concerned. 7 days time may be given, Lordship.
2, 3, 5, and 6.
3, 5, and 6.
Before vacation, any date, Lordship.
7 April. Obliged, Lordship.
That's your lordship. Lordship, amicus curiae, lordship, no. Oxo case, lordship. Amicus curiae maybe, upon lordship, we have taken step.
Awaited, my lord. So far. Steps were taken by speed.
Tracking report. Shows that the circumstance. Scan.
Obliged.
Lordship, the charge sheet submitted, the Lordship call for the scan copy, the NDPS case number 25, 2026. Began session just Boingal.
Submitted the charge sheet.
Bit number 96/25 dated 31/12.
NDPS case number 25. Point.
CR along with CD.
Let me give in, Lordship. Bill, Lordship, 24, Lordship. Twenty-eight, Lordship. April 28.
Second step on 16.3.
Awaited, my lord. 16/3, they have taken steps, my lord.
Is that steps have been taken only on 16. Mile, can it be on 8th mile? Can be on 8th mile.
Eight.
8 तारीख होगा. अब last mile.
Please, your lordship, kindly pass over the matter for a pen.
He called for it, not received.
Timing. 3 days.
Rested on 16/2.
Already timing.
Eight, please, your lordship. It's a, it's a case, my lord, registered under 21B, my lord. Intermediate quantity, my lord. 73.24 grams, my lord. And my lord, in the case, in the instant case, my lord, that 7 witnesses are there, my lord. My lord, is the trial, my lord. Moreover, my lord, on ground, my lord, the lordship turns to page 36, my lord. My lord, the arrest memo, my lord, where the signature and the name of the relatives, friends or witness of the arrestee, my lord, it dated to be sent by W2 message, my lord. So 48 notice is also not available, my lord.
FIR.
Lordship will find the FIR at page 10, my lord. Lord, the operative part, your lordship will find at page, my lord, 12, my lord. That yellow color flag, my lord. WT message, my lord. Acknowledgement, my lord. My lord, may I rely one judgment, my lord, of a division bench, my lord, which was passed yesterday? One paragraph I will show. Paragraph, my lord, lordship will go to page 16, my lord. The second last page, my lord. Paragraph 8, my lord. Lordship got it, my lord. Paragraph 8. When the constitution and the statute prescribes the manner in which a person may be deprived of liberty, that mandate is absolute.
Paragraph 8.
8, my lord. Second last page, my lord. My lord, this is a concurrent judgment, my lord. My lord, from my lord, page 15, your lordship will see, my lord, concurring opinion, my lord. Page 15, my lord. Page 15 is a concurring opinion, my lord. That's why I am relying, my lord, that paragraph 8, my lord. When the constitution and the statute prescribe the manner in which a person may be deprived of liberty, that mandate is absolute. Any infraction is not a matter of irregularity, it is a constitutional breach, and the court are duty bound to remedy it. Lord, page 12, my lord, of that judgment, my lord, paragraph 17 may also be kindly. Page 13, my lord, paragraph 20, my lord, kindly be. Follows that this principle that the constitutional mandate under Article 22(1) requires the grounds of arrest to be furnished to the arrested person and his relative nominated person. In your considered opinion, merely because the arrested accused person chooses to presented by lawyer and prefer bail application, that would not substitute for lack of or gross inadequacy in furnishing grounds of arrest.
That is concerned, it will on the record, my so far merit is concerned, then both of them, the Doing was seized from them, my lord.
Intermediate quantity, and they have spent, I think, how much time?
146 days, madam, as on today, madam. As my.
Violation of. I cannot today.
Wheelchair, madam. Wheelchair.
Accordingly.
Should I given two sureties or one, madam? I'm applying.
Updated, my lord. So,
Here, my lord.
CD has been received, but the same is not updated.
seven, my lord.
7th May.
7 May.
Highly applies.
My lord, it was sent for item 20 is my CD1 updation.
Not an additional pin. The first earlier.
April. Ma'am.
Yeah, please, Your Lordship. I'm on interim and Lordship. Yes, Lordship, this is a sessions tribunal case, Lordship. Devotion. A sessions tribunal case, Lordship. That's why I'm praying for making it absolute, and Lordship's order is also there. Tribunal. If I appear, I may be arrested. Senior citizen of 68 years, Lordship.
This is a different.
This is different, but Lordship, here, what happened, the actual fact is,
here.
Lordship, this is a sessions
On
tribunal
interim
case, and it is not committed.
Seven. Case number doesn't need. CS number is was submitted on 6/1/2026.
Even delay. Applies. Interim may continue.
This anticipatory bail, going to the court's record, my lord, I find that it was never came up for motion. It was always listed somewhere in the bail hearing. Then it was tried to be placed before the appropriate court. Because a co-accused was given an interim bail. I have annexed that to at page 19. And ultimately it was found that on 9/10/25, charge sheet was filed in this case. And my lord, that order I have taken it out, my lord. Now this, ultimately this order was passed in that page 19 order. This culminated into this final order. Co-accused, my lord, named in the FIR both. Only distinction, my lord, there was an interim here because it was always in the bail hearing column, my lord. Never either it was taken time, then it was for the appropriate court. That way, my lord, it was never been heard in motion court.
One now, same order.
The lordship can, because till I appear, some interim protection. Give me some 10 days time, my lord, I will appear. Ten days, my lord, from the date of receipt of the certified copy, my lord.
Trial court, madam.
Of his arrest. Accordingly.
Plus,
Amicus was appear. There is amicus.
I filed the wakalatama. I'm praying is, my lord, let the matter be taken up at 2 p.m. and the informant, my lord. So I p.m. my lord. Please, my lord. For delay, my lord, at 2 p.m. Yes, I'm deeply obliged.
Yes, please, your lord. Yes, your lordship, the accused behind the bar since 39 days. All hearing is 96. One is the commission of offense in a worship. The malicious act intent to outrage the religious feeling, and 3.5 is a common intention, and section 13.1 is a slaughter of cows. The lordship here maximum and 39 articles has already recovered herein. So serial detention warranted, your lordship. That's right.
FIR.
Your lordship will find it page 12.
It did not receive.
Well, my CD not received, my lord.
Azuddin and Roisuddin.
Lordship, he is the main accused, my lord.
I have been shown as a main accused. Rickshaw puller herein and other is a daily laborer. Herein in the place of offense. Main accused person who has fled away is the main has done the
It is my total 1022 kgs.
What time will you produce CD? What time will you produce CD? Statutory period will be over.
Before the, my lord, due vacation,
At 1st of April. Is
1st of April, my lord.
Office note, sir.
yes, any report?
No, my lord. Kindly allow us some time to get the report, my lord.
You get.
Lordship, may kindly 24th or till, my lord.
2017, how long can we keep wait?
The earlier case also stayed there, my lord, cannot.
It available with. Fixed.
Yes. Wait. Sunday, my lord, 27, my lord. Yes.
Lordship, as per official manner, service has been awaited manner, but we have taken step twice manner.
Officer concern.
We have taken steps on 6.
Such person. His address. No such person in the address.
Manner.
No, you have to get the proper address. Six, unserved note. Of concern PS. Is there in that address? Ascertain the address.
Published.
Lordship, the has not been received.
There was sent. Transmission of the
Obliged.
Wait, please, your lordship. So basically, your lordship, today, the IA has come. We have filed this IA under section 430 for suspension of sentence, and this case, my humble prayer will be with regard to only one point today. That is, your lordship, that the appellant was arrested on 21/1/2021. Already 5 years and 2 months have elapsed. Therefore, your lordship, as per section 479 BNSS and section 436A of CRPC, your lordship is entitled to, your lordship, bail and suspension of sentence as per law, your lordship. Subsequently, also, your lordship, he was actually convicted for 10 years of rigorous imprisonment and 1 lakh fine under section 20B of NDPS. But only prayer is, till the hearing, your lordship, he is entitled to bail. Lordship, with regard to that, if your lordship wants, I would like to place decisions on that regard, whether he is otherwise entitled to as per the statute. And in fact, in Satyendra Kumar Until case, it has become stated to be a mandatory provision so that a person should be granted bail on that ground itself. This honorable court has also passed a few orders on that point itself. Refer to, and in fact, in appeal also, it will continue. That is what I'm trying to find. A very long judgment, your lordship. Para 46. I'll refer to the page number that is below page number 43. 43. Down below on the right hand side. Para 46, your lordship, is that? Yeah. That, your lordship, section 436A of the code has been inserted by Act so and so. The provision audible object behind it, particularly from the point of view of provision draws the maximum period for which an undertaking has to be reckoned with the custody of the accused. I've already explained the word trial will have to be given the expanded meaning, particularly when an appeal or admission is pending. In this case, it is an appeal. Thus, the case when an appeal is pending for a longer time, to bring it under 436A, the period of incarceration, all forms will have to be reckoned, and so on. This provision, when a person undergone detention for a period exceeding 1/2 the maximum period of imprisonment specified for that offence, shall be released by the court on his personal or with or without sureties. The word shall clearly denotes mandatory compliance with the provision. So this is basically the judgment that he is otherwise entitled to bail. Secondly, your lordship, there are other of our honorable other two following the same, your lordship, judgment of Satyendra Kumar until two other judgments. One has not even referred, one has referred Satyendra Kumar.
These are very recent judgment, I think about a week or 10 days. Both those cases, your lordship, 5 years, more than 5 years, those are all 10 years of conviction on the NDPS, both these two cases. Both these two cases is 10 years of conviction, fine, and the Satyendra Kumar until bail was granted. That's it.
Now, 430 will apply. And the quantity what it is of I hear the whole matter. The whole matter be heard. Judgment. Heard and this. The appellant being.
In fact, the appeal has not yet been admitted.
And let it be disposed of. Entity lordship, and I reading lordship, I don't know.
I'm basically on the mandatory provision. Earlier section 436A of these sections have been very clear. Granted bail, and which has been, your lordship, upheld by the honorable court in Satyendra Kumar. In fact, in one of the judgment of the honorable judgment, not followed. I'm not referring that case, but in that case, the honorable Supreme Court has been very strict on it, saying that it should have been followed. Were disappointed with that particular High Court has been specific. First paragraph.
That this is applicable only to trial, not to appeal.
29 would be for trial.
479.
479. 430 is to the appeals. Now, there is a case where now only after the registration the appeal will be heard for a long time. That would have been the appeal be heard lordship instead of
entity by your lordship Satyendra Kumar until judgment paragraph 46. Why I'm referring to that? I think your lordship knows it. My learned friend is saying that. This is. Paragraph 46 of the Kumar
Until refers to 436A. That equivalent to 479.
479.
But in appeal, that is covered by 430.
30, but certain, that is why I refer to Satyendra Kumar until paragraph 46, which says that trial will also include expanded meaning, including appeal and admission. Para 46, your lordship. So it was brought under 436A. Fact, your lordship, way back in 1999, Bhagwan Ram Shinde Gosai versus State of Gujarat fixed, and your lordship, these are all cases where after conviction they have come. Yeah, that is the reason.
Like there are other judgments of the Supreme Court. Half the period is undergone.
Yeah, that is there. That is what my only prayer is there, because my learned friend has pointed out. That is why I pointed out that it should. Otherwise, the statute is very clear. The judgment is there. If your lordship wants, I can refer that, because that was this is also a new judgment wherein the sentence is different. These judgments all are more than 10 years. This is 4 years of POCSO. Here also this court was, I can refer just for lordships. If your lordship wants to see that, I can go. Here also this is a recent judgment, DDS. Court was very disappointed when the Supreme Court has stated the word disappointed. I did not want to put it, but anyways, your lordship can read that. And have referred to one judgment of 1999 that I didn't know. I've come to know from this judgment. Lordship will just read paragraph 2 for a moment and then turn to paragraph 12. Why they were disappointed, that is the reason is there at page para 12, your lordship will kindly see. This judgment I have come to know recently, that was an earlier judgment in 99. Says the convicted person is sentenced to a fixed period. If it is a fixed period, then if it is a life and then case, your lordship, that will not happen. Beyond that. Life, there is no fixed period. Then if it is a fixed period, then half of the period undergone.
Trial court. So and so. 5 years.
5 years, 2 months as of now.
Sentence. And then appeal is pending. By the appellate court. Liberally, unless they. Inder Kumar until CBI reported in 36A of the file. Extended meaning. Is for a fixed period of 10 years. Statutory provisions. And so. Shall be.
Appellants, that
Of the. Is the appeal pending for condonation of delay?
donation has been, it has been,
Has to be registered now.
now it has not been raised.
I think it has been registered. There is a number.
It has been registered, 350. It has not come.
Appeal 315, right? Hard learned counsel.
Obliged.
For orders or only? For receipt of TCR and all.
Obliged.
Step height speed post lordship. Yes, sir. So there is a direction prosecution to take action with this or not. a POXO matter, but lordship, step was taken through speed post, lordship.
The case for not POXO.
Not POXO, lordship. The victim as respondent number 2. On 23rd,
Yes, prosecution. So, my lord. Now. Through the my lord PP, the
that order we have taken.
yes.
On 23rd, there is a direction that instruction was given to the served or not, lordship. First step
First
through
steps.
PP, lordship.
Yes, my lord, yes.
As lordship, she
I
could not
think
be
no
traced up,
necessity.
lordship, then only this order from the trial proceeding. I have filed this IA 1350. That case also notice. IA 1358, there is an order passed to trial court as he is lordship. Her appearance.
Not any.
Type my prayer, lordship.
High weight of. Absolutely. A has been preferred. Things in. 599 of 20 pending before learning. Connected criminal petition. The next date.
33 to
Five nine nine of. Order.
take fresh step, Lordship. Correct? Obliged, Lordship.
Right on the IA.
IA also, Lordship.
Till returning.
Obliged, Lordship. Obliged.
So, Lordships, the FIR is at page number 18, operative portion.
You have gone through.
TCR not received, my lord.
Is there, your Lordship? This
But not reflected in the court list.
Yesterday I have appeared before this honorable court.
I think it was somebody submitted, it was a voluminous TCR, so time was required to go through.
Oh, yes, my lord.
What else is there?
Kindly fix that too, my lord.
My instruction, my lord. There's no objection if he's there.
You have to file an affidavit.
My lord, only question, my lord, kindly see, a third person has come. Actually, he says, informant says, my lord, the victim is his sister. In fact, she is outsider, my lord. And only with him, I had some, my lord, problem, some monetary problems over there, my lord. So he might have set up that, yeah, my lord, that's why. And you'll also kindly see whether anything is there, my lord. For my information, nothing is there, my lord.
FIR.
Yes. The FIR is page, you'll also for 9, page 9.
Well, he,
First, you'll also see whether it is correct, my factual part. Whether victim is his sister or not. From the address itself will appear on. He has given your address in the FIR itself, my lord. Victim address. Senior daughter of Anna Saleh. He is saying his sister. His father's name is, your loss will find that is Imtazal.
Sister may have been used in a local variation.
No, everything is different, my lord. The PS, resident of district, everything. Their
How
district
come there is
Kapiala.
so much material in the CD against you? Statement is there. All right, you file your Yes, they intend to file an up to them, otherwise we'll go by the.
I'll file the affidavit, my lord.
Who? In that case, interim may be given, my lord, because ultimately identity is completely, somebody else has been set up, my lord.
In view of the submissions made by learned PP.
Obla.
My lord, this case is my learned friend will submit on merit, my lord. Staying on merit, my lord, but here the third, my lord, FIR investigation has completed, and in the charge sheet, my lord, he is trial, my lord. It may kindly that merit will in the merit also.
If the case has been charge sheeted
Lord,
and you are not named therein, then what remains? How is this
yeah,
maintainable?
and I have also seen the last my lord, investigation. Lord. There is nothing that he
Yes.
Please, may I please? Yes.
not what pertains to my lord, the very that maybe my lord decided.
May I please? Your Lordships? FIR is at page number 18, operative portion. My name is not there, Your Lordship. Very true. Charge sheet to be corrected is supplementary charge sheet, not the absolute final charge sheet. At page number 19 to 31, operative portion is Your Lordships, page number 31 to the bail petition. The first sentence, moreover, the prosecution sanction under the Arms Act and Explosive Act is pending. That is the reason why supplementary charge sheet has been. Now coming to the point, Your Lordship, why I am coming before this honorable court is very well explained in paragraph number 6 to my petition. Lordship. The officer in charge of the North Lakhimpur Sador police station is constantly coming to my house since August 2025, December 2025, January 2026, as well as February 2026 during the pendency of this anticipatory bail petition. Now the reason behind that, when the police had come to the house of the petitioner, he was not present because he runs an rental vehicle business. Or other businesses are also there. He travels across the country. Fortunately, he was not there. His wife was present. His wife was picked up by the police in due process of the law with women police and all those. Took to the police station. She was interrogated, Your Lordship, and thereafter a sign of her was taken in a white paper. Thereafter, she was sent back to home. Then, Your Lordships, the other co-accused, there are total 10 number of accused persons in the FIR. 8 have been charge sheeted in the supplementary, and 2 have been not charge sheeted. It is also very well in my petition, page number 3, paragraph number 4. It is there. So, out of this 8 number of persons who are charge sheeted, Your Lordship, one of them is my sister-in-law's friend. He, after on bail, informed my sister-in-law that he has heard amongst the accused persons inside the jail that my name has been uttered. That name may have been used in the 180 statement. I understood the gravity of the scene, and thereafter police has come to me later on. And then, Your Lordship, in order. So my humble prayer is that, Your Lordship, I know my name is not there in the FIR, not in the charge sheet. No notice has been issued to me. But Lakhimpur police is bothering me. And your lordships, to satisfy you more, to come to the conclusion, me, Advocate Shomik Shur, in person, had visited the OC, Lakhimpur Sadar Thana. He informed me that so-and-so person is involved in bomb blasting, this, that, etc. Apuni tak loi ahok, ami korim. Now he's apprehending his arrest. So let him appear, let the issue be solved, let the police be clear, let me be clear. If I'm involved anywhere, I'll cooperate with the trial. I'll cooperate with the investigation. Trial is a further speculation. Apology. I submit my case, Lordship. Be kind enough, Your Lordship. Just to go and sit with the police, inform them, talk to them, so that they don't bother me with the arrest. Sections are very hefty, Your Lordship. 10 years, life imprisonment. May sit, Your Lordship.
The part charge sheet.
Part certainly it is written. It is, part search is a first submission of my learner. Nothing of the CD like that, my lord. And
It is a hearsay thing, Your Lordship. I accept it. I admit it.
that some names, my lord, in his name, my lord, but that is, that search sheet has been filed.
Your Lordship, bail is a right. Bail should not be never denied if merit is there. My learned senior friend has very rightly said, nothing is there, no connection, why I'm here. Your Lordships, it doesn't make the point very clear on the prosecution side that police is searching me, go to jail or get harassment from the police and then come back to the Honorable High Court, take a bail, be free, then face the trial. That is not the process of due process of law established by the lawmakers of this country, Your Lordship.
Stated about the present petitioner in the charge sheet.
No sperm.
The entire course of the investigation, he was
Never been interrogated, nothing. Oh, no accused has taken his name. To that. Next one. Page 21. Particulars of accused person search sheeted. The name came during the investigation, but name not there in identification and my lord. That's
As per the understanding of the trial court record, accused number C in the charge sheet, page number 22, Sanjeev Borua, he is not still on bail, Your Lordship. All others are on bail because they are not connected directly to the matter.
Does that concern you?
No, Your Lordship, the point here is that I believe, as per the record, but it's a matter of trial, that he may be crime. Your Lordship. Some very difficult for the petitioners. We can't.
We'll just say not to disturb him. That is all. There is no case against him.
my lord, subject to correction.
There is a categorical statement on affidavit that police has been. That.
Lordship, it is on affidavit, Your Lordship. And this is out of the affidavit. I myself in person have visited the OC. Refused to talk to me first, Your Lordship. This is off the record. So this is a. But I have to say the fact. This is very true. Sorry, sir.
I heard learned counsel for the petitioner and learned medicine in application under so and so.
Supplementary charge sheet.
Not charge sheet, not subsequent. Charge sheet is filed after.
Much obliged, Your Lordship. Thank you.
His name nowhere. Stating that The police are of the petitioner. 5/12/25. Like that the name of the in the
Take my lord. If it- any, my lord. Record, my lord. A report from if he.
Interim may be there, your
Then-
lordship.
we are not disposing of. Getting the it shall be open for the
set of matters. The earlier RFA was arising of 86/10, filed by the husband and wife, two suits filed by husband and wife. Husband sought to purchase a ground floor space of 1,000 square feet. Wife was purchasing around 1,300 square feet first floor. The intention stated was to make a doctor's clinic of both the spaces. the occasion we had argued on behalf of the husband's case, stated that the agreement provided only for space. There was no flat as such. However, it was assured that the builder would make certain efforts to secure a frontage area and commercial life permissions for taking the doctor's clinic. That was not granted. The municipal MD, etc. did not permit. Therefore, the husband said that he wanted to exercise his option of a contiguous 2-bedroom flat parallel to his wife. Now that contiguous 2-bedroom flat was nowhere assured or promised to him by way of a separate agreement. It was not there in the original agreement. And we, however, we said that contiguous may not be possible. It could be there non-contiguous, another 2-bedroom flat. That option was not exercised by them. Therefore, they said that file the suit paying for certain either 2-bedroom flat contiguous or in the alternative compensation damages. The Honorable granting them 12 lakhs, the amount which they stated to have paid with interest. On the issue of interest, I had raised the point that the agreement envisages 10%, whereas the trial court granted 12%. And that was at that point, the cross-examination objection they've also filed, cross-appeal. As stated then that the question of damages and assessment of compensation, there was no evidence was laid on that point. Assess how much they had suffered, whether they had not established any clinic at that point in time, monetary cost, basically. That was the part regarding the husband's ground floor flat. But here we are come back to the wife's case, which was filed by way of a separate title suit and decreed giving the wife her right to get back possession of the flat which she had purchased in the first floor. That is where, if I may just take the operative part of the judgment and decree. That is at page 125 to 144. The operative page. The order at page 137. This is title suit 185 of 2010, filed by the wife. So 137 order, heading order.
Is decreed on contest.
Suit is decreed on contest. I am sorry, my lord, this may be pagination error. I will 134. Next page would be 135 then.
What is below at order?
Then the 7 is written as 4. There may be.
Then is 30.
In any case, my lord, I may just simply that at that page order is decree for specific performance of registered agreement for sale. So 8706 dated 6 July 2007, Exhibit 10 in respect of Schedule A flat. They are liable to execute the registered sale deed in favor of the plaintiff in pursuance of agreement for sale dated 8 September.
I think you are reading something else.
This is an RFA 119. The 2 items. This was we argued on the earlier occasion. There is another next item.
Item also.
Item 38, I believe.
Yes, 130.
Page 137. Plaintiff is entitled to decree for specific performance of the registered agreement for sale, number 8706. Case of the husband, it was 8705, executed on same day. from defendants 1 and 2. Defendants 1 and 2 are liable to execute registered sale deed in favor of plaintiff in pursuance of agreement for sale. Effect of suit on any day within next 60 days, having received the entire sale consideration amount already from the plaintiff. Finding is that we have received the entire sale consideration amount. They are directed to hand over vacant and peaceful possession, and in event of failure or to execute the sale within 60 days shall be executed and registered by the court. Therefore, my lord, the Honorable Trial Court decreed the suit for specific performance and rejected their claim for compensation and debt. Admittedly, without discussing on the issue which they have raised on the cross appeal, at the points of whether they are entitled to that compensation or damages as well was never discussed by the Honorable Trial Court, although it may be said that no evidence was led in that regard. The reason for this, I will find at page 134 or 133. It starts from 133. The main discussion of the learned trial court on this issue. Issue number 5, page 133. The main issue on facts. The others are simply maintainability on the issues of I may read, well. 34. Issue number 5, down below. Since this is the issue related to specific performance of registered agreement for sale bearing so and so, I have gone through the contents of document due care. On page number 2 of the said document is written that on the application of second party plaintiff for allotment of 1 3-bedroom flat measuring 1375 square feet on the first floor, bearing allotment number so and so in the complex known as Megmurla Hillview, at so and so, and on being agreed by the second party to purchase 1 3-bedroom flat as described in Schedule C of the agreement on the first floor for consideration of 13,50,000 against cost of floor, roof, proportionate share of land and consideration charges, including raw materials, which is to be fully paid as per Schedule D. Agreement in question was entered in between defendant number 1 and represented by defendant and plaintiff on the terms and conditions as set forth in the agreement. Now, the point herein is that agreement was entered into between the plaintiff and the defendant. In this suit, defendant number 1 and 2 have not filed written statement. We have been granted leave of the court to simply cross-examine on the limited scope of their case, to disprove their case. That is only to the extent of the appellant's case hearing. The defendant 3 filed his written statement, filed his evidence. I am not on that. In this point is that the agreement was signed by the plaintiff, is filed by the plaintiff. Evidence, only sole evidence has been led by the husband of the plaintiff in the other suit. My lord is well aware that husband under section 125, husband or wife is a competent witness. Of that I am not disputing. Husband may have personal knowledge of some of the aspects, but husband cannot testify as to the willingness, readiness aspect of his wife to pay the amount for the flat in question. There are two properties. One is the husband's own property, which is a subject matter of a separate title suit. One is the flat, which is his wife's property. Now he cannot claim that is his property in law. Wife, who is a separate person in juristic entity. That is his wife's property. Wife has filed a suit. In the pleadings, he has not mentioned that I am authorizing my husband as power of attorney to depose as power of attorney to file this case with this power of attorney document. In the verification paragraph, the certain paragraphs are made as true to her knowledge, not the knowledge of her and her husband's or her husband's solely. The sole witness in this case is the husband of the wife. There is an infirmity there, which the Honorable Courts have time and again pointed out, that the husband can depose as a competent witness, but competency of the witness has to be distinguished from knowledge. Can be competence. Now, in the pleadings, my lord is well aware that the pleadings have to lay the foundation for whatever evidence has to be laid. In the evidence, the husband files his evidence stating that I am competent to file evidence. He does not even state that I am deposing on behalf of the plaintiff herein. He files his evidence as a sole PW. And thereafter, he brings as exhibit number 1 an unregistered, unauthorized power of attorney, which is dated of September 2013. It is filed in 2010. Cause of action arose in 2006. Power of attorney to depose comes in 2013. It's not even a case where the power of attorney is prior to the filing of the suit. So therefore, there are the reason assumes significance for the reason that because they have mixed certain facts here. My lord is well aware, I was referred to the document therein, that they have shown a receipt from the builder wherein both husband and wife are stated to have paid 31 lakhs or 30 lakhs together. There is a receipt on record. They are relying on that receipt to prove the amount that they have paid as consideration. Now the question arose, how much money was paid by the wife? How much money was paid by the husband? Two different agreements, two different sale considerations. Checks have been paid. He admitted to receiving around 18 lakhs. But they have stated they have paid 31 lakhs on the strength of one money receipt of 31 lakhs. Now the question comes, is the husband paying the check, the deposit money from his own account? Is he transferring the money from his wife's account as a power of attorney holder? There is no averment to that effect. And finally, how can the husband testify as to his wife's willingness and readiness to pay the remaining amount? Because there is a remaining amount. Initial amount, they said they are willing to pay as per the two agreements, 9 lakh and 13 lakh 50, around 22 lakhs for both the properties. Let us take it together. 22 lakhs 50,000 or 22 lakhs 80,000. Thereafter, the plaintiffs herein, they filed this, they have alleged that they are willing to pay 33 lakhs for the entire premises, provided it is made suitable, becoming a doctor's clinic. Of that, they have admitted to have paid 30 lakhs. Let us assume that story. But that 30 lakhs is in toto. It is not divided. Parts of it has been paid in check, part of it has been paid in cash. And the receipts mentioned received towards payment of Jotia flat. This is there in the record. It is not mentioned which flat number, which number. Again, now the question comes of evidence. When the husband, has the husband made an averment that he has been authorized by his wife to enter into all transactions in respect of her flat? His flat, we are not in issue. His title suit, his property, the ground floor property, he is competent to dispose of his own transactions. That is not an issue. But question comes to the second suit, the second appeal, wherein it is his wife's property that is in question. Now, my submission is that the Honorable Trial Court erred in taking into, and the Honorable Trial Court has discussed this point. I would like to take my lord to that aspect. They have cited a judgment of the Honorable Supreme Court, but not appreciated in its correct perspective at page 135. Read this entire paragraph. Further, this fact is not at all in dispute that the plaintiff and her husband, being doctors by profession, wanted to set up a doctor's clinic cum chamber, and for the purpose on the same, they entered into two separate agreements with the defendants and also jointly made payments to said defendants in respect of the suit flat as well as the suit property involved 135. In title suit 186 of 10, this is 86 of 10 filed by a husband against the defendants. Under the aforesaid circumstances, the argument of learned counsel for defendant that the evidence of Dr. Kishore Kumar Das, the husband, cannot be taken into account since he is not the plaintiff and party to the agreement with the defendants is not sustainable. Decision rendered in Man Kaur by LRS versus Hartar Singh 2010 10 SCC 512 further fortifies the fact that the attorney holder can depose in respect of matters which are within his personal knowledge and which he has handled, or the acts of business which he has transacted on behalf of the principal. There is no argument with that proposition. In para 18, the Honorable Supreme Court, while summarizing the position as to who should give evidence in regard to matters involving personal knowledge in clause B of said paras, laid down if the attorney holder has done any act or handled any transactions, then in pursuance of power of attorney granted by the principal, he may be examined as witness to prove those acts or transactions. If the attorney holder alone has personal knowledge of such acts, the transactions are not the principal. The attorney holder shall be examined if those transactions have to be proved. So, my lord, proving certain transactions which he was handling alone. Secondly, he alone has personal knowledge. It is nobody's case that the plaintiff does not have personal knowledge of what happened, who purchased her property, her flat. She knew. She filed the case also. In pleadings, she has not even stated that my husband is the one who has personal knowledge of all these transactions. I have no knowledge. I have merely signed on a dotted line. If that were the case also, then this proposition would be applicable to the present facts. But in this, again, the Man Singh is basically a long line of decisions which have laid down this proposition should, and that is there are other matters as well, ma'am. Now there is this earlier judgment was laid by Janki Vasudev Bhojwani versus Indasin Bank Limited in 2005 to SCC 217. I will hand this over to my lord, but this is again on the lines of Mansingh with a little bit more detail, which I, apart from what has been stated, if I may read this judgment, my lord. Apart from what has been stated, this court in the case of Vidyadhar versus Manik Rao, 1999 3 SCC 573, observe at page 583 that where a party to the suit does not appear in the witness box and states his own case on note and does not offer himself to be cross-examined by the other side, a presumption would arise that the case set up by him is not correct. In civil dispute, the conduct of the parties is material. Now, my lord, again, in the case of Shambhu Dutt Shastri versus State of Rajasthan, it was held that the general power of attorney holder can appear, plead, and act on behalf of the party, but he cannot become a witness on behalf of the party. He may be a competent witness corroborating the evidence led by the plaintiff, the examination team, but he cannot be the sole witness. He can only appear in his own capacity. No one can delegate the power to appear in witness box on behalf of himself. To appear in witness box is altogether different act. A general power of attorney holder cannot be allowed to appear as a witness on behalf of the plaintiff in the capacity of the plaintiff. That is the point I'm trying to urge. He can depose as on behalf of the plaintiff, but not in the capacity of the plaintiff. And this is, my lord, I'm presenting these two cases, Janki Vasudev Bhojwani and Pushparani S. Sundaram. These are all on the same, and Vidyadhar versus Manik Rao as well. These are all on the same points, that he is deposing in the capacity of the plaintiff who was his wife, without authorization, an unregistered power of attorney executed in 2013, around 7 years after the cause of action first arose and after 3 years after the suit was filed, and that too not in a representative capacity. That was the point I'm trying to make, my lord, because I am handicapped in this appeal. I have not filed written statement. The only thing I can do is point out the infirmity in their case. And so far as the cross appeal is concerned, cross objection, my lord, I again state that this is no evidence has been led to show the damages suffered thereby. So whatever they have said, how far they have been affected, their earnings, income, no evidence has been led on that count. And even though an appeal is a continuation of the suit, whereby any defect they could have had till this date, they could have had the opportunity to adduce evidence by the plaintiff or the respondent herself, even at the stage of the first appeal. If this error were inadvertent due to a misconception of law, and then till date no application has come forward for adducing any evidence. They are simply reliant on the evidence of the husband on the sole ground that the husband knew of the transactions. Contention is that he may know, but how does he know which transaction was made for particular his flat or a wife's flat? If he's paying in toto, that would be incomplete evidence. It would not signify proof that payment was made specifically on behalf of his wife towards her property. That is my submission, my lord. So far as this case is concerned, in case required, I'll reply.
My lord, that our argument really bifurcate much went against whose account was also argued in the first case. Your evidence where there are separate exhibits against each payment, few addressed to the husband, few addressed to the wife. Now, for this appeal also, if a lordship has 70, it's part of the plain.
Yes.
Lordship will find
chart.
there's a chart. And there are corresponding exhibits which I had shown for the husband. I can also show. This argument hardly carries any weight, also in view of the fact that the suit proceeded ex parte and these pleadings were never disputed. Cannot now come in appeal and say that we don't know, it's a cumulative payment, we can't bifurcate. So these paragraphs go uncontroverted. There is no written state. There are supporting exhibits. Oh, coming to the other issue regarding whether the husband could have deposed on behalf of his wife, as is being suggested. Now, if your lordship has the plaint itself, plaint lays the foundation. Para 8 onwards. It's not as if the husband is acting on behalf of the, deposing on behalf of the wife on the basis of that supposed part of it. Deposing because he is the one who has been corresponding with the builder, and that foundation is laid in the plain. All correspondences are from the husband. In fact, in the plain, we have categorically stated that it is the husband of the plaintiff who was informed about the non-allocation of grant of permission. It is the husband of the plaintiff who kept on requesting the builder, developer, or the defendants to sort of honor the contract. So he has personal knowledge. Now, going by that proposition, because ultimately the judgment has to be read in the context of facts, it's an authority for the facts it decides. And therefore, then going by that judgment of be Janki Prasad or that subsequent judgment of Mankor, it clearly says that when the attorney otherwise has personal knowledge, then he is competent to depose. Paragraph 18 of that judgment is where the points were formulated and the law was laid down. Are perhaps covered by B and also the other 18B. If the attorney has done any act or handled any transaction in pursuance of the power of attorney granted by the principal, he may be examined as witness.
Janki.
No, Lord, Mankor, which was handed over by my friend. So this judgment is for the proposition that just because you have a power of attorney, you do not become a competent witness. It is limited to that. If the person concerned is the one who's handling the transaction, he has personal knowledge. Therefore, you can the courts will not disregard his evidence only on the ground that you have a power of attorney. It's rather the other way around. That only because you have a power of attorney, you will not we will not consider you a competent witness. Another very important aspect which your lordship will take note of is the relationship between the plaintiff and the witness concerned. They are husband and wife. Now, the moment they are husband and wife, my lord is aware of the Evidence Act.
He has also admitted 125.
No. Yes. 120. My lord. On to 20. Parties to civil suit and their wives or husband or wife of person under criminal trial. In all civil proceedings, the parties to the suit and the husband or wife of any party to the suit shall be competent. Second part, we are not concerned, that's dealing my lord, criminal cases. So going by the relationship, regardless of whether I have a power of attorney or not, I can still depose because I am a competent witness under section 120. That's point number one. Point number two, I can depose on the basis of my personal knowledge for which foundation has already been laid in the plain. That's number two. Number three, my lord, if your lordship has the the evidence on affidavit, my lord. The first paragraph of the evidence on affidavit, if I may just read, I'll just later on mark it in the LCR. Yes, my lord, while deposing, the first paragraph he says, my lord, that I am the husband of the plaintiff and I am in the know of the facts and circumstances of the case. I further say that I was involved in the in respect of the dealings of the flat in question, which my wife Madhumita Das Majumdar had entered into by an agreement so and so, and as such I know the facts and circumstances of the instant case. Further, I have been authorized. That's page 35. Of the memo. So this first portion, that I was the one who was I was the one who was involved in respect of the dealings with this flat also. That statement has not been controverted in the cross examination. Of course, there were questions like where is your power of attorney, etc. But this factual statement that I had made was not controverted during cross. I had the occasion to argue. Lord has para 10 and page at page 6. That was the point for determination 1. Here also, my lord, that was the questions your lordship finds at para 9. We're concerned with 9 Roman 1, my lord. Page 6, my lord.
10.
Para 9, first the question, my lord. Para 9, first Roman 1. Whether non-examination of the respondent number 2 was the proprietress of the respondent number 1 firm would disentitle the respondents for any decree as prayed for in the plaint. Now, that is dealt in at para 10. It is not disputed, rather it is admitted by the appellant in his written statement as well as in the evidence on affidavit by the appellant that he handed over the daily accounts as well as daily cash to appellant so-and-so as well as to her husband, namely so-and-so. It is also seen that husband of the respondent number 2 had lodged the FIR with the concerned police station. In the statement dated so-and-so bears the signature of Sanjeev Goswami. The same person is the complainant as per the charge sheet submitted in connection with Panbaza case so-and-so. Hence, there is no way to hold that the husband of the respondent number had personal knowledge of the transaction with regard to which he had given evidence in the suit. Not only the connection of the husband of the respondent number 2 is disclosed in the plain, but his association with the respondent number 1 firm and respondent number 2 wife who is the proprietress of the respondent number firm, is squarely admitted by the appellant. It is also the specific defense of the appellant in the written statement as well as so-and-so evidence on affidavit that his blank signatures were taken on the letter pad of the respondent number 1 by the husband of the respondent number 2 by threat and force, which was later on converted to his account statement showing due payable to respondent number 1 firm. Therefore, there is nothing to hold that Sanjeev Goswami PW1, the husband of the respondent number 2, was not a competent witness to depose on the basis of his personal knowledge. Moreover, the learned counsel for the appellant could not show that there was any cross-examination of the PW1 on the point of his authority to depose on behalf of the plaintiff. Now, if your lordship may skip over to C. And as per the provisions of Section 120 of the Evidence Act, 1872, the husband or wife of any party can be said to be a competent witness in all civil suits. Under the circumstances, when the admitted pleading by the appellant in his written statement that the husband of the respondent number 2 participated in the affairs of the firm of his wife, that is the respondent number 2, this court is of the considered opinion that as competency of PW1 to depose on behalf of respondents has not been questioned by the appellant before the learned trial court or in the course of cross-examination of PW1, the respondent number 2 cannot be non-suited at this appellate stage. For the reasons as stated above, this court finds that the ratio of the case of Ratan Dev referred to by the learned counsel for the respondent is found to be appropriately applicable in the fact situation of the present case in hand. Thus, in view of the discussion, the point number determination 1 is answered in the negative and against the appellant by holding that non-examination of respondent number 2 proprietress of the respondent number 1 firm would not disentitle the respondents for release as prayed for in the claim. So here also, my lord, lordship sees both the matters, all the correspondence are with the husband only. Was purchased in the name of the wife, no doubt about it, my lord. But all pleadings will also show everything, all the dispute, the arguments also with the respondent, the husband of the respondent. So that is one aspect of the matter. I believe that there are two facets to the argument of my learned friend. First of all, husband could not have deposed. The judgments deal with that, my lord. And secondly, that the wife did not enter the witness box. But that is also not an inflexible rule. When there are evidence to show that what had transpired between the parties, mere non-examination of the plaintiff herself would not be fatal. You know? That is what was referred to in Ratan Dev. And Ratan Dev also held that it is not an inflexible rule. At times, if the
merely a presumption against the plaintiff, but
yes,
it can be rebutted by other evidence.
Yes.
Probably.
There also.
But what about his contention that the husband deposed to the readiness to perform the remaining part of the contract? That was his submission.
Readiness, willingness is already taken care of. I've already paid the money.
There is a remaining amount, according to him.
According to them also. We have paid around 33 lakhs in total. One flat we did not even get. So the price of the flat of the wife is close to 18 lakhs. So I've paid in excess, in fact, and that is why the refund has been ordered. Now, perhaps your lordship is referring to that allegation where they have said that they have not disputed the total amount, but they've said that part of it has gone for interior works, which was also their case in the other appeal.
Probably.
So
that was not spelled out specifically.
That was not. Now, therefore, my lord, now that it's an ultimately at the end of the day, it's an ex parte decree. You ought to have denied the statements made in the plaint, and you have also led evidence to the contrary that no, he was not ready and willing. This is what has happened actually. Nothing on that record. So given this, my lord, and ultimately, my lord, the agreement is admitted. The payments are not disputed as it ought to have been. Why did they hold on to the flat, my lord? Because of the dispute concerning the other flat. So perhaps that was an arm twisting mechanism that we will give you this flat provided you withdraw your challenge insofar as the non-delivery of the other flat is concerned. This is perhaps what may have been there on their minds. Far as the other, before I go on to the damages part, if I before I move on there, my lord, the cross-examination, my lord. No, if your lordship may kindly have the plaint. From page 26 onwards, my lord. I'm sorry, page 27, my lord. Gradually moving on to my cross objection, my lord, because that is where the issue of damages, as my friend has argued. Now, page 27, para 21, I have given a detail of the damages that has been caused to me. Say I suffered from mental agony, I could have converted the chamber cum clinic and I could have generated revenue out of it. And after saying all this, we claimed a total compensation of 13 lakh. Now, this paragraph per se is not denied because there was no written statement. If your lordship sees the judgment, Lord will not find any discussion on this aspect, the damages aspect. Though my statements had gone uncontroverted, my lord, I would say they were admitted in a sense by virtue of non-denial. But irrespective of that, that issue of damages was never even visited, my lord. So since there is no written statement, my claim for damages had gone unrebutted. Now, first of all, my lord, I would call it the errors are twofold. First of all, the court did not even consider that pleading, did not visit that aspect of the matter. And secondly, even in that issue where it was what relief am I entitled to? They granted me specific performance, but the court lost sight of section 21 of the Specific Relief Act. Madam. Power to award compensation in certain cases. In suit for specific performance, the plaintiff may also claim performance for its breach in addition to such performance. If in any suit the court decides that the specific performance ought not to be granted, but there is a contract between the parties which has been broken by the defendant, and that the plaintiff is entitled to compensation for that breach, it shall award him compensation accordingly. 3 is what we are covered by. If in any suit, any such suit, the court decides that specific performance ought to be granted, but that it is not sufficient to satisfy the justice of the case, and that some compensation for breach of the contract should also be made to the plaintiff, it shall award him such compensation accordingly. So despite there being pleadings, there being a prayer, this was totally lost sight of. This provision was not even taken note of. And ultimately, the words used are is not sufficient to satisfy the justice of the case. Now, this flat was supposed to be delivered on 6/7/2010. Now we are in 2026. So by this time, maybe now it is totally in a dilapidated condition. We may have to renovate the entire flat. and not even a single penny has been awarded for. And the moment they decide specific performance in my favor, it means that I have always been ready and willing. So if I have been ready and willing since 2010 till 2017, no compensation was deemed necessary to satisfy the ends of justice. And now the requirement is even more because it has been taken in a appeal unnecessarily, and now we are almost years past that initial date of delivery. Therefore, my prayer is that your lordship will maintain the judgment insofar as specific performance, but also consider my cross objection for grant of compensation for the delay that has occasioned. But similar that is an argument made also the other appeal. There, of course, they had a written statement. There, my lord, how did I calculate the compensation is by saying that this is what has happened. Now, if your lordship has 116 for a moment, let's it collectively. One moment. Para 21. Without prejudice to what has been stated herein above, I suppose 28. Plaintiff alternatively states that if this honorable court is however not inclined to grant specific relief of specific performance, the plaintiff is entitled to recovery of money already paid to the defendants along with interest and for compensation for the injury caused to the plaintiff as already stated herein above. The ground floor more specifically mentioned Schedule A to the plaintiff was an integral part of the setting up of the doctor's clinic. The actions of the defendant respect of the Schedule A area have made the plans of the plaintiff to set up a doctor's clinic impossible, thereby causing losses to the plaintiff. The action of the defendants amount to breach of contract for which the plaintiff is entitled to special damages as well as general damages. It is stated that as the plaintiffs, after realizing the fraud by the defendants upon him, had inquired with various real estate companies in respect of similar areas as mentioned in Schedule A to the plain, and could come to learn that the present rate is rupees 1,850. The plaintiff had also to suffer mental as well as physical agony on account of the illegal actions of the defendants. Further stated hearing that the plaintiff has invested his hard-earned money to set up a doctor's clinic, and the illegal actions of the defendants, apart from causing physical and mental agony, had also caused great financial loss to the plaintiff in respect of the professional work. The plaintiff prays for special damages of the amount. Now it says financial loss caused to the plaintiff in respect of his professional life on account of the illegal actions of the defendants calculated at rupees 1 lakh from so and so. Loss caused to plaintiff both mental and physical on account of illegal actions of the defendants. 3. Loss caused to the plaintiff on account of breach of contract calculated in the following manner. The rate as per square feet on the date of agreement, rupees 930 per square feet for the ground floor. Present rate is 1,850. Difference is 920 square feet. Now, the argument, if I've understood it correctly, that there is no basis for calculating the compensation. Now, serial number 1 is saying that is my prospective income that I could have generated from my professional life by opening the clinic, come doctor's chamber. 2, of course, is mental agony, etc., which is the discretion of the court. I have put in specific figures to show that now if I go looking for a similar space in that particular area, I have to pay rupees 930 per square feet more than what I had invested. So that is how I'm trying to take care of escalation. Now, an argument was made that how do we get these figures of there being an increase of rupees 930 per square feet as on the day of filing of the suit. But for that, my lord, their own witness has admitted these figures, and in fact, it turned out that these are conservative estimates. The escalation is much more higher. Now, I have flag marked DW3, the cross-examination. Has DW3 was the second day of cross-examination.
Yes, DW3.
DW3, the second day of cross-examination, which was held on 23/2015. I think it should be internal page 7 if it's a photo.
So, no, this is page, page.
Internal page 7 insofar as my certified copy of DW3 held on 23/2000. Further cross of Utpal Das, DW3. Tag mark is the first page of the cross-examination of tag is the start of the cross-examination. Flips a few pages. Second day of cross-examination.
Did 20,
20th March. Now I'm doing construction of buildings at Jury Park. Now I'm doing construction of buildings at Jury Park, which is under Shankardev, near Shankardev Kalakshetra. The sale rate of the flat at Jury Park is 2,600 per square feet, which is inclusive of the garage. This rupees 2,650 rate is on the super built-up area. The sale rate at present in the building where the plaintiff had purchased the flat is rupees 100 and 150 more than the sale rate of the building I am presently constructing. So, Lord, our estimation was in fact on the conservative side. We had said 1,850. He says in Jury Park it's 2,600, and the place where I had booked the flat, that will be more than that. It will be 150 rupees more than that. So it'll be 2,750 rupees more, as opposed to the agreed rate of rupees 930. So it's almost 1,800 now, the difference, as we had claimed just 930, my lord, but it appears from their own admission that it'll cross 1,800, more enhancement of more than 1,800. And this was in 2015. Another 11 years have gone by. Aware of the both far as my this is so far as my third head of damages is concerned. Say if I go looking out for a flat of that nature, I'll have to now pay more almost per square feet, as in on 2015. So far as this first head is concerned, that I lost out on prospective income, etc. I must bow down, my lord. There are no materials, and the courts have also said that when it comes to loss of profit, the courts cannot devise a precision formula to sort of calculate how much the loss it will be. So some amount of guesswork is inevitable, because all of it will be notional.
Heads of compensation are firstly loss of income.
Loss of income. Second is mental and physical agony, my lord. Third is loss. And there are other factors, where both of them had taken loans.
Third is escalation of price.
Third is escalation. So far as third is concerned, my lord, the DW's evidence would suffice. Of course, it's very subjective, mental and physical agony, my lord. As far as the first is concerned, when it comes to loss of profit, Supreme Court has said that when it comes to some amount of guesswork, there cannot be we cannot travel to minutest of details. A broad evaluation is sufficient. We on our own had assessed that damage as 6,50,000. And so far as the wife is concerned, we've also said similarly loss of income, etc., and mental and physical agony. And those statements were not even controverted, because there was no written statement. Of course, on the quantum, my lord, it's always the discretion of the court. And so far as loss of income is concerned, my lord, as early as 1984, this is 80 Bridgewall Singh, my lord. Paragraph 12, my lord. This was, of course, is in the context of works contract, my lord. Paragraph 12, my lord. Paragraph 12, the 11th line from sentence begins with our opinion. What? Paragraph 12, 11, stop, in our opinion. After that sentence, exhibit 77 to 7 lines from there, in our opinion. Is your lord? In our opinion, while estimating the loss of profit that can be claimed for the breach of contract by the other side, it would be unnecessary to go to the minutest details of the work executed in relation to the value of the work contract. A broad evaluation would be sufficient. We in this connection invited both Mr. So-and-so and so-and-so to give broad features of the work as well as the portion of the work executed by the appellant. Having heard them, we are satisfied that the appellant should be awarded 12 lakhs under the head of loss of estimated profit for breach of contract by the respondent. On similar lines is another judgment which says that some amount of guesswork is inevitable. Relevant paragraph is para 9. It's a longish paragraph. If your lordship has page 506, first bridge pulsing has been cited, and page 506 is Salamatullah was also discussed. (506), the third paragraph, to the same effect, after Brijpal Singh was quoted. The same effect is the judgment in Muhammad Salamatullah versus Government of AP on Andhra Pradesh. After approving the grant of damages in case of breaches of contract, the court further held that court was not justified in interfering with the fact given by the trial court regarding quantification, even if it was based upon guesswork. In both the cases referred here and above, 15% of the contract price was granted as damages. In the instant case, however, the trial court had granted only 10% of the contract price, which we feel was reasonable and permissible, particularly when the High Court had concurred with the finding of the trial court regarding breach of contract by specifically holding that we therefore findings recorded by the trial court that the defendants, by rescinding the agreement, committed breach of contract. It follows, therefore, as and when the breach of contract is held to have been proved contrary to law and terms of the agreement, the erring party is legally bound to compensate the other party to the agreement. The appellate court was therefore not justified in disallowing the for rupees 20,000 on account of damages as expected profit out of the contract, which was found to have been illegal. So that mathematical precision will not be possible, and therefore, my lord, maybe grant whatever reasonable or little compensation your lordship finds to be reasonable. Not trouble your arguments that were advanced, just to wait for my satisfaction, my lord. The first case was a case where they said that they'll give me the ground floor of the building, and they said we will apply for the permission and we they kept on deferring, they kept on sharing plans that this is what we are seeking approval of, etc. Suddenly, they one fine morning they say no, GMDA doesn't permit, so therefore you can take it as is varies basis. So basically, I take a garage sort of an area, and then they said we had only promised you the space, free to take it. In fact, we've already allotted you that space. You do whatever you want. Now, during the cross examination, your lordship will recall that was their moot defense. The GMDA does not permit us, therefore we cannot construct. Then during cross examination, the director himself says that firstly, 3-4 takeaways from the cross examination. Firstly, he admits that he knew of the bar of the GMDA before even he entered into agreement. Secondly, he also admits that he did not even file a formal application for approval of the plan that he had shared with me. Thirdly, he also admits that he received payment and there is no document to show that these payments were adjusted for some interior works, etc. Because there could not have been interior works, the flat itself was not constructed. And fourthly, he also recognizes the signature of his own employee who had been receiving. So therefore, we had argued that it will be covered by the third part of section 56 of the Contract Act, which says that if the promisor knew from the very beginning that there is a legal bar or there is impossibility and nevertheless induces me to sort of make payment, etc., then he is liable for compensation. Here, refund of that money will not be.
If I may submit only on the cross examination, that will clarify. I have the copy, right copy. my lord can read from here, it will be easier rather than going back into the records. So, cross of DW3 in this case.
And the one that was already referred to as just now.
For that was referred to as just now.
No, he's referring to PW1.
PW.
That's part of the.
PW1. This is PW1. PW3, no, this is PW1.
PW1, in fact, is a part of the memo.
Yes.
That's part of the record.
That's part of the record.
Page 50. In RFA 119.
For the sake of, I'll just
Certified copy you can read down the page.
I have noted down the page, Manu. That is that page wherein they have stated, if I may just point out, I kind of pinpoint from. But if I may just point out, I'm unable to find out here. They are A4 in letter size. Therefore, there is a slight problem here. I apologize. This is, I believe, yes, Miller.
You have the type copy.
I have the copy. I could not. I just did not. From the. This is just to clarify. Page 72. My lord may turn to page 72. The memo of appeal, page 72. Cross-examination. Start. On para 2, in my evidence on affidavit, I have mentioned that 33 lakh has been quoted for the entire area stated herein above as a unit. I and my wife jointly had paid 30 lakhs against the payment or request of this entire area as a unit. 2 points are clear from this. Admission is that they had agreed to pay 33 lakhs for the entire unit, not as per the agreements, but as per their own informed modified understanding, let us say. And they had paid 30 lakhs. So 3 lakhs is yet to be paid as on date. The question that arose, whether they have paid the entire amount. They have not paid the entire amount. Secondly, my lord, if we are to take this 33 lakhs and accept this, that would imply that both the husband and the wife are respective necessary parties in the other suit. The reasoning of the trial court wherein it was held that they are not necessary parties because there is no relief. Here there is an admission that there is a joint payment. If it is to be treated as a joint payment of 33 lakhs and a joint liability of 33 lakhs, joint payment of 30 lakhs, joint liability of 33 lakhs, then both are necessary parties. If not, then my understanding is that the agreements would have to prevail. The considerations in the respective agreements would have to prevail, not the understanding of what is later to be paid. Extra costs are included, modifications, construction costs, repairs are to be borne by whichever party. Those are all subsequent events. If those subsequent events modify the earlier agreement, then the question of misjoinder of parties comes in squarely. If this is a joint agreement, number one. Number two, if I may continue, I cannot say whether my wife can claim that she paid more than what was agreed to be paid. Here is an admission that he does not even know. He's deposing on behalf of his wife, the plaintiff, and he does not know for surety what she has paid. Number three, I am not in a position to say as to why I filed 2 separate suits instead of 1 suit. The number of the other suit is TS 86 of 2010. I had not agreed to pay the balance amount of rupees 3 lakh prior to execution of the sale deed. He has agreed that he is not willing to pay the balance consideration prior to execution. The court, I had agreed to pay the said amount of rupees 3 lakh after the handing over of the conveyance deed. I agreed to pay the stamp duty after the handing over the conveyance deed. I will not answer as to whether I agreed to pay the cost of stamp duty prior to execution of the conveyance deed. Now, how would a sale deed be executed without paying the stamp duty, bearing the stamp duty? All these are conditionals. Conditionality is imposed. The agreement says stamp duty is his responsibility. He says, I will not pay unless you hand me over the sale deed, duly executed, gift wrapped. These are subsequent conditionalities. I do not know whether any specific statement has been made in the plaint or well as in my evidence and affidavit that I agreed to make the payment of the balance amount as well as cost of stamp duty prior to execution of the conveyance deed. I know that my wife suffered immensely, but I cannot say about the valuation thereof. I have also suffered personally in this case. I personally do not know my wife suffered physical mental agony. I do not know the quantum or volume of the physical mental agony suffered by my wife. I will not bring my wife as a witness to prove the pain and agony suffered by her. There is again an admission that it is not a case of incapacity or inability of the plaintiff to testify. It is a pure unwillingness to testify. I cannot say my monthly income without seeing my balance sheet. I cannot say my approximate monthly income also. I cannot also say about the income of my wife without seeing a balance sheet. There is no proof of income. I cannot say about my bank balance without going through my balance sheet. I file my income tax returns regularly. My wife also files her income tax returns regularly. I cannot say the income shown in any income tax return as well as my wife without going through the balance sheet. I have not produced the balance sheet. The project was approved to be delivered by as per agreement, supposed to be delivered as per agreement by July 2009. Regarding the business loss of rupees 5 lakh as mentioned in para 21G of the plain, I can say about that only after going through the balance sheet. Something which has not produced, not proved. The business loss, he says, I cannot say anything about that. He does not know about the income. The question is, what has been actually proved about the financial status, the loss? If that be the case, then everything would be fine, conjectures and surmises. My lord would have to guess at every aspect of the matter, every financial detail, because they have not adduced even a financial detail, single detail. It is not a fact that my wife is not entitled to specific performance. It is not a fact my wife is not entitled to the claim of rupees 13 lakh and interest thereon. I am not interested to take my money back. There is again a blanket refusal to take the money back, with or without interest. Therefore, my lord, the question that I'm posing is, assuming this appeal were to be dismissed and they are getting their specific performance be upheld and they get a flat which has appreciated in value, admittedly, and on top of that, without adducing any evidence as to the loss or prejudice suffered thereby, merely by way of delay, when the time delay is shown to have been of advantage to them, as on date, if they take possession of the flat, that rate of 2,700 becomes 3,700, 4,700. They sell it, the compensation comes out. I sell it, I can literally pay them from the proceeds of the sale of the flat itself, whatever cost is coming out. Like it would be advantageous for me if that I were permitted to sell them and pay damages to them out of the said flat. But that is not the case, my lord. From this deposition, it is clear that the evidence has shown that they are not interested to take the money back. They do not want the flat. The flat they want, but provided a contiguous flat is provided, for which there is no provision in the agreement entered to with the husband. Therefore, in the other suit, since the law did not permit the agreement to be specifically enforced, the Honorable Court decided a particular amount was to be refunded back. On top of that, now the wife is saying that I will not testify, I will not depose as to my loss. Husband says, I will not depose as to the plaintiff's loss or her income or what she would have suffered. And on what basis would a court on facts adjudicate and give a verdict as to the quantum damage? Again, my lord, again I reiterate that if the agreements are sought to be specifically consideration thereof would either the flat would be handed over to them or the amount paid by them would be refunded back to them with the interest envisaged in the contract. If they desire that a 33 lakh promise for 2 flats, contiguous flats, has to be enforced by way of subsequent conduct between the parties, then the facts would itself reveal parties are necessary parties. That would have been a common suit. The payment liability is joint, as has been repeatedly urged in their pleadings that I do not know. In law, it may not be joint, but from their pleadings, it appears that they have taken this upon themselves as a joint liability and as a joint payment, a discharge of liability, and even a joint delivery of the properties in question. If that be the case, and if the relief sought is in terms of that right being claimed, 33 lakh valuation of both properties in question, then number one, the entire valuation has not been paid. Number two, they are not willing to take the refund of the money back. Number three, they are Honorable Court then below erred in holding that there was no misjoinder of parties. The court proceeded as these were two separate suits. In fact, my lord is well aware that evidence led in one suit cannot be taken into consideration in another suit if it has not been led separately in that suit as well. He cannot go between the suits. There is admittedly a strange situation wherein these are related facts. Nobody is disputing that. But to the extent of the knowledge of the plaintiff on one hand, the extent of the damages suffered by them, extent of the consideration paid by them, their willingness and readiness to accept the properties back, everything, even as on date, is in doubt, is shrouded by doubt. That is my leave to
I think.
Ground floor, I can. Had paid 12 lakhs, that breakup is evident from the plain. I had paid 12 lakh, so trial court has said give back to the husband. That everything is sorted. Whether I'm entitled to compensation or I have paid a total of 30 lakhs. 18 lakhs has gone from the wife. That is also clear from the record. And therefore, Malad, I have already paid more than what was needed. If we bifurcate, 18 goes on account of the wife, 12 goes on account of 12, nothing comes back to me because the flat cannot be. So far as the wife is concerned, wife has already paid 18 lakhs. Those figures are not disputed. Cross-examination that read out was in respect of the wife's naturally says that I'll not take money, because why will he take money when the flat is ready in the first place?
Save.
Deeply obliged.
Lordship, my senior has some urgency work, so he left the court. So kindly pass over the matter for the day. And
Child Protection Act, my lord, for complaint there in 2025, my lord, against me and other. Then, my lord, case is pending, my lord. And before the trial court, no final report was filed. And case is not case is pending since then. It is more than 11 years, my lord. In the meantime, I got retirement. And because of that case, my lord, I cannot get my pensionary benefit. My name is involvement here. In fact, my lord, they cannot able to get the final report. They are in a position to file the file. This is a false and concocted allegation against me and other people. They are not able to file the all correspondence are made by the court, court concerned to file a final report to the investigation agency, but taking time on and on since 2015 to till date, my the case, my lord. There is no more since 25 only the
Is
complaint.
the status of the case?
Status of the case, a complaint is filed, and thereafter case has been stopped. My last order missing the last order, my lordship. Paragraph page 64. Inquiry into the offense report such and such submission of the final report regarding. It is then informed that the further investigation of ORFSL such and such dated 2/3/25 since long pending. You are therefore appointed as the investigating officer respect to the above committed Magoni village under Gauhati police station 1/3/2025. Copy of the preliminary offense report is hereby enclose your reference. Please carry out the further investigation. The offense report such and submit your final report along with the issue process that is. So that is complaint filed on 1/3/2025. There is no case. Case is not pending. No progress is pending. No notice has filed. No final report has been given. Nothing has been recovered from me, my lord. That regulation is there.
The complaint is annexed?
Yes, my lord. It is annexure B.
Is 45.
No, my lord, page 35. I did, man.
Your name is mentioned.
Dimbasar Boragwai.
You are a government servant.
Yes, my lord.
How are you in the picture?
My lord, the allegation is that my lord, some people has gone to purchase horns of this and they are intercepted this particular person in a car, but nothing has recovered. The false allegation, my lord. Has been recovered.
Yeah, FIR, it says 5 persons listed below.
Name of the person on page 20, lordship may see page 24, 28. Boragwai, Dimbasar Boragwai, Dimbasar petition. About other parts.
That the offense report has not been submitted.
No, my lord. And Lordship may see the Caesar report. Caesar is page 26. In the vehicle there, page 26. Vehicle such and such Scorpio, RC vehicle, RC bike, pollution certificate, vehicle insurance, RC two-wheeler such and such, and photocopy of the court of debit, and list of Indian currency and cell phone equipment. Nothing is recovered from me. Nothing is happening like that, my lord. Lordship may see page 53. The court of SDGM Gaupur. Case record put up before me today, that on parallel of the case record, it is seen that last order in this case was passed on 16/10/2015. And this order is 15/11/2021. I have perused the later part of the order dated 11/4/2015, passed by my predecessor in offense office, where has been entirely held that the said order, that the investigation officer in the case of Mr. Pallab Kumar Deka, AF Assistant Conservator of Forest, and his letter number such and such has entirely stated every effort are being made, being taken to nab the remaining culprits, and there is a possibility of recovery of arms used in rhino poaching. Final reports will be submitted soon, and after apprehension of the remaining accused. Is thus held that the said order at such and such that the investigation process is going to be considering the above and other reason. The registration of CR case was held be premature. Since 16/10/2015, CR has not been put, and the probable case is likely to be no final offense report has been submitted yet. Hence, in my view, there has been an inordinate delay by investigation agency, investigation officer for submission of the final report, which the Assistant Conservator of Forest in his letter dated 9/4/2015, Supra. It demonstrated that it would be submitted soon. The premises of the I deem it appropriate to call for the status report and the investigation of the case, but no status report was submitted till date. Thereafter, the court order is there, only issue reminder is there. Call for the status report, yet not received. There is the CR, it has been received. It's ineligible, waiting for status report.
Twenty 2022, a new officer was appointed.
Yes, madam.
That what did it
No,
do?
nothing has been given. No report. Ten copy of this case has been called for. It was received. This learned friend is not.
On what ground are you seeking?
Gentlemen. Actually, my nothing here is nothing recovered from me, my lord. There's no allegation against me except this complaint, my lord. Had there been there is an allegation, there be a final report, I could have. No allegation, no final report, no statutory report. And my lord, although every.
We'll do it again.
Worship on last occasion.
Regarding
In your worship.
some talking was going on. Then what happened? Instruction, no.
The matter is sent to mediation, then I think the matter will be sent.
Yes, has been sent. Has been sent. Last time it was said that petitioner will apprise the court as to when he will be available for mediation.
Yes, that is.
Last week of April.
Of April. For the petitioner, that the petitioner will be available at Gauhati. First week of to appear before the. Because there is no time for notice, we'll fix a date to appear
Yes,
there.
it will be better.
When? Seven, appear before the mediation. 7th of April. Date.
Last week of June.